Rochelle Becker.
I'm Rochelle Becker with the
Hello.
Alliance for Nuclear Responsibility. And we did sign on to the subcommittee's comments. However, our alternative would be the no alternative. That doesn't mean that they don't comply. It means that they don't operate when this license is up. This board was asked to decide whether or not they would give them permits when they operated the plant, when they first designed the plant. They didn't meet those compliances. It took years to finally get their NPDES permit. Now we're back at the Water Board looking at permits again for an aging nuclear power plant. License amendment requests, license amendment requirements are not included in Bechtel's summary. It is highly unlikely that there won't be a reason for a license amendment request, which would further delay and cost more. Legal challenges are not included in this. When the agency said, yes, you can get a permit, that doesn't mean they're going to give them a permit. It just said, we haven't seen all the documents, so we're not sure whether we're going to give you a permit or not. We do know that the no alternative, closing the plant by the end of its current license, certainly worked well for San Onofre, which closed early. You saw almost all of the impacts of once-through cooling disappear. We have no power shortages in San Diego County. I have a second home in San Diego. I haven't been without power for any reason. We're water shortage, but we don't have a power shortage. Diablo Canyon is actually in a better position than San Onofre was for being overproducing power in its service territory. So when you consider alternatives, the no alternative, the condition that you may operate this plant to the end of its license, assuming you can operate it safely and assuming for PG&E that it's cost effective, it would be okay. But adding another 20 years onto the life of this plant, which is what PG&E would have to do to justify the costs of this, is not an alternative that ratepayers are going to happily make. It will be challenged. And so I think that this board needs to carefully consider my community, which loses a great deal of resources, a great deal of money if this plant closes down, the opportunity to know that this plant will be phased out in a certain period of time. Therefore, we can plan for the alternative power, we can plan for alternative resources, we can do this in an actually proactive way than a reactive way for an old nuclear power plant that probably doesn't meet its seismic requirements. We sat through an independent peer review panel meeting yesterday that doesn't meet once-through cooling requirements unless you exempt them, that has aging issues. This is a money pit, and we've gotten the best we're going to get out of Diablo Canyon. It's not going to get any better, and I'd like my attorney to have the rest of my time. Thank you.
Good evening, John Geesman on behalf of the Alliance for Nuclear Responsibility. I'd like to briefly elaborate on some of the points that Rochelle made. Before I do, let me say that it was perhaps predictable that Mark would be as vehement as he was this evening in expressing his opinion that the policy would be wholly unreasonable if applied to Diablo Canyon. You should know that when the Bechtel Phase 2 report was initially published, that PG&E told the San Luis Obispo Tribune on November 2nd, 2013, PG&E will comply with the once-through cooling policy. They didn't say that it would be wholly unreasonable to apply it to Diablo Canyon. They said they would comply. This plant is a very, very old plant. When I came before you in January and asked that you give Bechtel more time to complete their work, I identified the actuarial lives of the other California nuclear reactors. Diablo Canyon since then has gotten older. Unit 1 is at 75% of its original licensed life. Unit 2 at 73%. The prior record in California for age of a reactor was San Onofre Unit 2, which achieved 71%. So we are already in an actuarial no man's land with this plant. And if it does in fact survive to the point in time where your policy would actually impact its physical design, it would be 1.4 times the age of the oldest reactor currently experienced in California. I drive an older car with a lot of mileage on it, and I know that repair versus replace decision becomes a lot more prominent as a piece of equipment gets up in age. And I would submit to you, this plant is substantially up in age. What was notable about Melissa's comments were the California Energy Commission, the California Public Utilities Commission agree that you have no basis to exempt Diablo Canyon from application of your policy. When I was in state government, having the staffs of those two commissions agree on something was a very rare day. I'm not suggesting that we declare a school holiday or anything, but you should take note of the fact that the two principal energy agencies in California at the staff level both say no basis for an exemption. Let me point you to two other inputs from the California ISO that bear on this point. In 2013, the ISO published studies that found that Diablo Canyon, or the absence thereof, would have no significant impact on California's electricity grid. This is radically different from the circumstance at San Onofre, where the Southern California grid was centered around the plant. Diablo Canyon, in the words of the ISO, is just another gentie. You wouldn't miss it from a grid stability standpoint. In 2014, just a couple of months ago, the ISO published studies focused on 2024 and determined that with Diablo Canyon, you would have substantially greater curtailment of renewable energy projects than would be the case without Diablo Canyon. So ask yourself, why does it make any sense to prop up this marine life incinerator with an exemption so that we can curtail the operation of the renewable technologies that it's been California policy for 4 decades to try to commercialize? Recognize that this plant, as the loads in California and the intermittency of the generation both change from what they are now, operation of this outmoded plant will have a big impact on the state's renewable policies. The Alliance for Nuclear Responsibility has believed since 2011 that PG&E is concealing a breach of the plant's seismic design basis. And it's recently become public knowledge that the NRC's senior resident inspector drew the same conclusion and recommended immediate shutdown until compliance can be established. I would submit to you that it is by no means assured that this plant will still be operating in 2024 when your policy would otherwise take effect. PG&E is the only NRC licensee in the history of the commercial nuclear industry in this country to face criminal prosecution by the federal government for safety-related felony violations. While 27 of the counts focus on the gas pipeline system, the lead count, the introduction to the indictment, is generic and aimed at PG&E's corporate management. And it says PG&E did corruptly influence, obstruct, and impede the due and proper administration of the law. It doesn't say attempted to impede, it says did impede. PG&E's recent judge shopping scandal at the Public Utilities Commission is just the latest evidence of a severely damaged corporate culture. At some point, one has to ask, is PG&E the type of institution that an advanced civilization entrusts its single most lethal non-military activity to? None of these issues is directly before you in the decision that you will be making, but each of them sits on the perimeter of the choice you will make. Choose well.